Welcome to Lecture 14 in our series on medical law and professional ethics. Today we are going to be going over minors in healthcare law and ethics. We will be describing the legal responsibilities of parents. Whoops, bumped my mic there. So describing the legal rights of parents and the rights of children. We will discuss confidentiality a little bit. Describe specific rules for minors in regards to reproductive health, discuss laws related to mental health, describe the laws affecting minors related to cosmetic surgery, we'll explain the laws related to minors and body art, and explain labor laws related to the health of minors, and finally how federal and state laws address child abuse. So that's quite a bit. Let's get started. A minor is typically someone under the age of 18 or younger than the age of full legal responsibility if that age is different than 18. And generally, minors are considered to not have developed sufficient knowledge, judgment, and maturity to decide important and complex matters. So they're not permitted to vote, enter enforceable contracts, consume alcohol, volunteer for the military, and in most cases, consent to health care. As children mature and grow older, different rights are granted to them, including the right to work. And the text does mention 16, but there are different states and different rules and regulations that allow different amounts of work, down to, I believe, the age of 14 in at least California. At least I can tell you it was that way back when I was 14, because I promise I was a working 14-year-old. Generally speaking, rights can only be taken away from parents or guardians in extenuating circumstances, such as child neglect, and then legal guardians are appointed by the court. In situations such as divorce, one parent may have physical custody of the child while they have joint legal custody, both parents. But laws have been established that allow minors to make some healthcare decisions on their own and obtain medical testing and treatment without anyone else being notified in certain circumstances in certain states. Typically, in non-emergency situations, minors require parental consent before procedures. However, this power is not absolute. When the parent or guardian's healthcare decision conflicts with the desires of the minor, a minor can petition the courts and try and argue for the decision which is in the best interest of their own health. They may seek court action through an adult representative called a guardian ad litem. There are also emergency situations, and in those situations, care can be provided without any consent under the implied consent principles we've discussed before. Emergency care doctrine assumes consent when somebody is incapacitated and is dealing with a potentially life-threatening condition. All right, the next section we talk about is reproductive health, which I feel like I would be remiss if I did not mention that today it was the day that the Supreme Court decision was leaked that they will potentially overturn Roe v. Wade. So I'm going to turn the camera off and then talk about how I feel about that, and then I'll turn it back on. So it's just been a rough day, and I don't know if all my Laffy Taffy is going to cut it. We'll move on to the reproductive health section, where I want to just kind of put in, honestly, a correction. In the first paragraph about contraception, they talk about unplanned pregnancies, STIs, AIDS, and other health complications can occur when sexual intercourse takes place. And that's just not true. AIDS doesn't take place when you have sex with somebody. HIV transmission does. There's a somewhat subtle difference between the two, but not so subtle that a medical ethics book should miss it. So I'm sorry for that. Maybe I'll have to eat another Laffy Taffy about it. So Roe v. Wade extended rights to minors as well as adults. And the government cannot restrict a minor's access to contraception without advancing a compelling reason. The Title X Family Planning Program provided funding for clinics to provide treatment regardless of age or marital status, and these clinics always provide confidential services. It is important to note, though, that if parents are unaware and do not consent to treatment, they also do not have to pay for it. All right, from this we skip into sexually transmitted infections. I don't know exactly why that's in the minors section. But it's important to know that there are certain laws regarding notifiable diseases that doctors and labs have to report, including HIV, AIDS. All new cases need to be reported to the health department. These laws pertain to minors as well. And in addition, in many states, if you have an STI, a sexually transmitted infection, you're required to warn your sexual partners or risk criminal sanctions. Generally, the infections included in these laws are HIV, syphilis, gonorrhea, and chlamydia. Nota bene, not always herpes. Our society has a very interesting relationship with that one. Some states also require doctors to ask newly infected patients about potential partners, previous partners through needle sharing or sexual intercourse that they might have shared the infection with. All right, according to the book, there's no federal laws addressing the rights of pregnant minors. Essentially, it is very hard to be pregnant and a minor. You get very little say in what's going on in your life. You generally will be able to access treatment confidentially for yourself, but you will probably not be able to pay for all the expensive prenatal care, which then makes the minor dependent on their parents who may not agree with that expensive prenatal care. Then the minor can petition the courts, and you can see, would you like to be petitioning the courts while you're pregnant, or doing some mommy baby yoga? It's very, very difficult and demanding for minors to go through pregnancy. And now we cross into the topic of abortion, which is at this point federally legal. But there are some states where minors do not need parental permission to have an abortion, while others, parental notification is required. And then finally, there are some in which the parent must give permission. And then I'm not sure, I don't think there are any that specifically ban them for underage women, which, that would be tragic. Although I guess there is a judicial bypass, which is available to women under age 18 who do not want to notify their parents or legal guardians, and that excuses them from the requirement. All states are required to provide this option to minors to want to have an abortion without notifying their parents, and in some states there may be a 24 to 48-hour waiting period from when they speak to a counselor in a clinic and when the actual procedure may take place. All right, and now on to the topic of mental health care, which I have touched on a little bit in communication as well, just trying to expose everyone to as many facets of healthcare as I can. Again, I'm not sure why this is covered specifically in minors. Honest to God, this should be its own chapter, but it's complex. Maybe that's why they've chosen to reduce it to this little section. So here we go. The big things they want you to know are that a minor 14 years of age or older can request outpatient care without notifying a parent if the treatment does not include medication. Care must be limited to 6 sessions or 30 days, whichever comes first. So that allows minors to get a little bit of mental health care, and then after that, the parent or guardian must be informed and give consent for continued treatment. So it allows kids to access mental health care on their own, but eventually they do have to bring in their family. During the first 6 sessions, the parent or guardian will not be notified of the treatment unless the minor consents or the professional feels the minor is likely to harm someone, including him or herself or themselves. Even in those situations, though, you should still notify the patient that you're going to be notifying their family. And as crazy as these situations sound, believe me, they do happen. My partner's worked a number of cases where children either threaten harm to others or themselves. So if that's an area that interests you, maybe social work is more up your alley than nursing. Consent is required from a parent or legal guardian for any cosmetic procedure performed on a minor. And in 2000, the federal government passed a new reg stating no one under 18 may undergo a breast augmentation procedure, even with parental consent, except for rare occasions in which it is truly a reconstructive procedure, likely secondary to breast cancer. Last but not least, body art. Tattoos and piercings have health risks Therefore, there are state laws that restrict minors from obtaining certain body art, and states that require consent of a parent or guardian. The parent must accompany the minor to the business and sign a document that describes the tattoo or body piercing. I'm sure that's an example. Not every state is like that. So I have managed to make it through to the next page in this lecture and section on child minors and healthcare. So child labor laws, the Fair Labor Standards Act sets out a lot of our foundational child labor laws. The law includes provisions that protect educational opportunities, prohibit their employment in jobs that are harmful to their health and safety, prevents children that are too young from working too much. Remember though, unless it's changed, 14 is the age where you can start working in California. You just have reduced hours, especially during the school year. All right, child abuse. Oh, CAPTA, the Child Abuse Prevention and Treatment Act, I think. Yes, okay, cool. It's federal legislation, provides minimum standards and funding for states to support prevention, assessment, investigation, prosecution, and treatment related to child abuse. So what does all this mean? What's the importance of CAPTA? All states have laws about child abuse, but each state's law is different. So this law set out, here's the clearinghouse standards. These are what you need to have. Each state must adopt these standards in their child abuse laws. So it's essentially the federal government setting minimum standards. This is why in almost every state there are certain people who are required by law to notify for child abuse, which we discussed in our 6th lecture in this series. So it can become difficult to differentiate at times between child abuse and discipline or traditional cultural practices. A great example is coining and cupping. Both of these are traditional practices, traditional healing practices. Cupping is where I think oxygen is evaporated from the skin, I think through a candle or something. I'm not an expert. Oxygen is evaporated from the cup and it's on the skin, so it creates a little vacuum, and essentially it creates bruises. Same thing for a coin. It's rubbing a dull edge of coin on skin and it bruises a little bit. These might look like and get reported as child abuse, but those don't actually constitute child abuse. Physically hitting a child as a punishment for something they did wrong, that is a much more, I feel like, cultural discussion. But as a nurse, I just like with abortion, I feel like when they give you your nurse card, you're like, oh, okay, now I must support abortion. Not that I wouldn't otherwise, but it's like a profession position rather than anything else. Like the profession position is don't ever hit your kids. Whether or not that should be illegal, that's a lawyer question, not a nurse question. So anyway, the marks left behind by coining and cupping do not constitute child abuse. All right, well, now we have reached the end of our lecture on minors in health law and professional ethics. So I will see you next week when we talk about, I'm guessing, either adults or the elderly in healthcare, medical ethics, and professional law. Professional ethics and medical law. Man, I'm really stumbly today. I think I had too much coffee.